probation has given me information to say that, yes, you're 100% clean and sober, you're on the right track, then I'll consider lifting that. But for now, it's no unsupervised contact. Court is calling 2024 CR 3308, State of Texas versus Decorian Trenton Smith. Can I have parties announced for the record for the state?
Andrew Harris Adlin.
Defense?
Eric Baker for the defendant.
And are you Mr. Smith?
Smith.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Smith, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Waiving the repeater offender enhancement allegation, Your Honor.
Any objection?
No objection, Your Honor.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Smell.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams? That is a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney and did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 6 years in the prison. State recommends community supervision. They're taking in consideration 719129. There's to be restitution under that cause number to Sergio Medina Jr. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of a cap of 6 years. There be no contact with Sergio Medina and a TAP evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Contained in Exhibit 1 and attachments, Your Honor.
No objection.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Here in states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I would, if I could take just a moment, Judge, and tell you a few things about my client, why I think he's going to be great on probation, deserving of this plea agreement. Just by way of brief background, he has 2 daughters, 12 and 13, and a 19-year-old son. He runs food trucks with his son, and so he will be gainfully employed day one when he gets out. Strong family support. I was just speaking to his mother for 20 minutes in the hallway about living conditions, and it's a support, very strong support net. Most of his family are very successful, educated. They're all behind him. They want him to come along and be successful like they are. And they are ready to help him on day one. And Judge, real briefly, I haven't seen somebody work as hard as he has in the last 7 months he's been in custody, Judge. If I could just go through briefly what he's done. He's completed the substance abuse curriculum and applying the cognitive behavioral approach, part 1 and part 2. He has certificates for all these, which I showed the state and I can show the court. Substance abuse curriculum, quitting alcohol, completed the personal recovery plan workbook, completed the applying the cognitive behavioral approach part 2, the substance abuse curriculum, completed an anger management training course through the Sheriff's Department through Anger Solutions Network. There's a certificate for that. He has a certificate for several more for substance abuse track classes, I guess. He has Getting Started, the Courage to Change series workbook, completed and got a certificate for that. 2 of those, I'm sorry, I guess there's part 1 and part 2. In addition, Your Honor, he has been religiously and continuously attending NA meetings at the jail, which I have a certificate here from the jail showing that. I've been very impressed talking to him. He's, like his mom said in the hallway, he's super intelligent. This is not the place for him, and his family knows it, and they're going to help him, Judge. And I think he's demonstrated in the last 7 months that, like he told me at the beginning when I first met him, it's like, I'm too old for this. Got lots of support. I'm going to get my life in order, and I'm going to start working right now. And he certainly did, Judge, and I've got all the certificates for if the judge would like to review them.
Oh, no, I'll take you.
Okay,
your word,
okay,
yes.
certainly. And so he's going to do great on probation, Judge. And I just wanted to, I felt like he did a lot of hard work, and I wanted to put that on the record.
I appreciate that. Does anyone want to speak to the punishment to be assessed at a cap of 6 years in the prison?
From the state's perspective, Your Honor, it is good to encourage someone who is diligently engaged in their own self-reformation.
All right, and defense?
Judge, I think it was just an agreed probation of 6 years, in the state, well, graciously, when I showed him how hard he's been working, said they'd agree to make that a cap, so the court has some flexibility in the term of probation.
All right, the court is going to sentence you to 6 years in the prison. Well, the court is finding you guilty, I'm sorry. Court will sentence you to 6 years in the prison, suspended and probated for 4 years. Take in consideration 719129. There's to be restitution and no contact to Sergio Medina Jr. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's going to be 120 sober meetings in 120 days. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Field visits 1 time per month for 4 months, and then at probation's discretion. I'm sorry, State, you may be excused.
Thank you, Your Honor.
And you know what? I'm sorry, instead of the regular random UAs, I'm going to want the UA hotline until further notice. He can have the TAP evaluation out of custody based upon the classes that you've completed. I know that you've been in custody for a while. Probation, if he ends up testing positive while he's awaiting his TAP evaluation out of custody, then he's going to end up doing the TAP evaluation in custody.
Yes, sir.
And we can do a referral to felony drug court out of custody. Make sure you make that appointment with felony drug court. There's going to be 120 hours of community service restitution. How far did you go in school?
I'm actually a medical assistant.
All right, so you're not going to be able to do that while you're on probation in this court. Do you understand? And when I say be a medical assistant, and what I mean by you can't be a home health care
No, I
provider.
work in the hospital. I work at Rehabilitation.
All right, doing what?
Pediatrics or emergency. the emergency room, but I have another.
I did explain to him,
Employment.
Judge, so he's gonna work for his son doing the food
Yeah,
trucks.
we're doing, I have a.
Unless he gets
business.
close.
Okay, you all are talking over each other in court reporter can't take you down. So you understand that on this probation, you're not allowed to be a home health care provider or work with minors, you understand? So that means you can't be a babysitter or any of that.
No, I didn't.
All right.
No.
All right, there's gonna be 120 hours of community service restitution. I'm gonna require parenting classes. Once he completes parenting classes, that will be deemed satisfied. And there's to be no unsupervised contact with minors. And that includes any minors. I understand you have children, but if you want to visit them or be around them, there's gonna have to be an adult supervising. You're frowning, you do not understand?
I understand, but I'm. Okay.
No, I mean, we can address it. Now's the time. If there's something that you don't understand that I'm asking for, if there is something that you're thinking,
I was wondering why would I have to have supervision with my children?
okay,
With the minors, like I don't have a.
all right. And see, it's okay to ask that question because sometimes people will think that I'm just giving them conditions just because, oh, here, you get candy, no. Let me just tell you the reason why I do it. The nature of the offense that you're here for, either you are a drug user or you're a drug dealer. If you're a drug user, you really shouldn't be around children unsupervised. If you're a drug dealer, you shouldn't be around children unsupervised because with drug dealers, there comes certain, or I should say drug sellers. I like that term better. There comes certain dangerous activities that are related to that. And if you are using, that's a danger in and of itself. Because if you were to become not sober, you shouldn't be around your children, period, if you're not sober. And everybody will do great work at the jail. It's rare, but it can happen where people get their life in order at the jail or at the prison, they come out, there's never any problem. But usually about 94% of the time, what ends up happening when people are confined or in an institution where they don't have the temptations, they do just fine. But then they get out, they go back to people, places, and things. And then the next thing you know, first thing they do, they miss an inmate meeting or something. And then the next thing you know, they miss reporting and they call their probation officer. I'm sorry I missed, but I'll be in there the next day. Then everybody starts backsliding and then they're using drugs again. And then the next time I see you, you have a motion to revoke. So yes, until I feel as though and probation has given me information to say that, yes, you're 100% clean and sober, you're on the right track, then I'll consider lifting that. But for now, it's no unsupervised contact.
Yeah,
You understand? Well, do you understand why?
I hear what you're saying, yes, ma'am.
All right, because at the end of the day, if I had your history, right? I don't think you would want me babysitting your children. You'd be like, Stephanie, everybody says you're great, but I can't risk it. And you're asking me to risk it with your children because they're your children. But my job as a judge is to put in place conditions of probation so that hopefully you'll be successful and that the community is protected. Going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. When people are at jail, they're ready to go. Your mom, your family member are 100% in it to support you. They want you to be successful. You want to do it for them. If you don't do it for yourself, then do it for them. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
You're welcome. All right, court is calling 2021 CR 4512, State of Texas versus DeMille Deshaun Thomas. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas. For defense, Elizabeth Russell.
And are you Mr. Thomas?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same DeMille Deshawn Thomas who was placed on deferred adjudication in 2021 CR 4512 for the offense of aggravated assault with a deadly weapon on August 23rd, 2021 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4, on or about the 15th day of March, 2024 in Bexar County, Texas. The defendant, DeMille Deshawn Thomas, did then and there fail to obtain and keep gainful employment in a lawful occupation in violation of condition number 4.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
Any objection?
No objection.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, it's to alter and amend for safety, hold in custody until he can be placed into treatment. And then alter and amend for a no contact order with Christina Miles, that the defendant be placed back into gang diversion upon release, proof of employment within 10 days, GPS work release for 6 months, and sober living home and zero tolerance.
All right. I don't understand why I should follow this agreement because this is his third motion to revoke. And I don't know if SAP would even accept him because he suffers from seizures. That's why he was released, because he suffers from seizures. So he suffered from seizures. And then with his previous motion to revoke, that was using controlled substance. That's why he was referred to felony drug court. And then he had another violation in September. And then those conditions, he was to be continued, and ISF and ISP. So it appears that he doesn't want to be on probation. I don't know if there's anything else to do for him.
Judge, and I understand that. And I do think that he does want to be on probation. He was actively looking for a job when he was arrested. He does not want contact with the mother of his child, the person referenced, Houstona, because he understands that when the two of them are around each other, it is not productive for either person. And he does want to be successful and no longer have the affiliations that have been placed on him. I think by revoking and adjudicating and sentencing him, he's not breaking away from that lifestyle. You know, I think typically in the Texas Department of Corrections, those gang affiliations become enhanced. And I do think that Mr. Thomas could benefit from the programs. He would like to speak to you as to why he thinks that he would be successful this time.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
DeMille Thomas.
All right, what would you like to say?
I really just want to stay away from her. I agree with the no contact order because like part of me using is her, you know, and it's not good. And I don't want to be around my children being caught up in negativity. I do want to be successful and complete deferred adjudication. I actually want to be something in life. So I do feel like the program would be good for me. At a point, I kind of feel like I don't want to go to St. Pete. I don't want to go to St. Pete, but not just because maybe it's the last thing going, but maybe maybe it could be the best thing for me. I'm tired of coming back and forth to jail. I just turned 32. I'm tired of getting older, and I don't want my kids to look up to me like my dad just some criminal. So I feel like it can work this time.
All right, the court is going to grant the motion, find you guilty. There's an affirmative finding of deadly weapon. There's to be no contact with Christina Miles, Claudia Lewis, LaShawn Robinson. The court will recommend therapeutic community. The court will give you credit for any time served. Does anyone wish to speak with in regards to time?
Can I just give 1 second?
Yes.
And Judge, we would request for, he does have young children and he does have some credit, about 590 days. And I think he would still serve some time and be released with enough time to get out of custody and help provide for those children.
All right, what has he done while he's been on probation? Has he completed anything?
He hasn't completed anything. He's done some of his community service hours. He has not made very much payment.
And I will let you all know, for the court, the payment is not at the top of the court's list. But what the court ordered for him is what I'm more concerned about. The CATs 1 and 2, did he do it? Community service hours, did he do it?
Of course, Judge, no. As far as the community service, he has out of the 150, 137 remaining.
I'm sorry, out of the what?
150 hours, he has 137 remaining.
All right, and he's been on probation since 2021.
Correct, Judge.
But he's also been in custody for 590 of those days.
But is that custody waiting for transfer? Or is that custody because he has a motion to revoke file?
I think some of it is the motion to revoke, some of it is transfer, and some of it is an inpatient treatment.
Okay.
Judge, just for clerk's record, we have 488. I know there are some days for treatment, so I just so I can add those.
Right.
All right, so the treatment days,
Yes,
are
Judge.
those treatment days where he successfully completed treatment?
Yes, Judge.
Okay. All right, and what are those days?
State ISF from October 30th, 2023 to January 29th, 2024 for a total of 91 days.
Okay. All right, this is what the court is going to do. The court is going to sentence you to the 6 years in the prison, give you credit for any time served, and the court will give you credit for any successful inpatient treatment. And the court will note for the record that he has a total of 91 days for ISF, and the court will give him credit for that. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes.
All right, you have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
And I'll recommend the therapeutic community. I do not have any jurisdiction over the therapeutic community. I can't force them to place you in the program. You'll have to ask for it, and whether or not they place you in the program will be completely up to them, but I will have it placed in the judgment. Once you're released from prison, which you'll be released,
Mhm.
once you're released, the first thing you need to do is find a place for NA or AA meetings, find a sober place to stay. Do you understand?
Yes, ma'am.
All right, good luck to you, okay?
Thank you.
You're welcome. All right, the parties on Mariah Rodriguez, please. Court is calling 2022 CR 7675, State of Texas versus Mariah Rodriguez. Can I have parties announced for the record for the state
Daniel Escobar for the state of Texas.
defense?
Ed Cano for the defendant.
And are you Miss Rodriguez?
I am, ma'am.
All right, you entered a plea of guilty on May 15th, 2024.
Yes,
According to the plea bargaining agreement, punishment is to be assessed at 2 years in the state jail facility. There's a $500 fine. State recommends community supervision. This will run concurrent with 685538. They will take in consideration 2023 CR 2440. You all need to whisper. County Court cause number 685330. There's to be restitution to Justin Alget, ALTGELT, Charlesty, CHARLESTY, Birchfield, BURCHFIELD, Latazua, LATAZUA, Wilson. Have both parties had a chance to review the PSI report? State,
Yes, Judge.
defense,
Yes, ma'am.
any objections?
No, ma'am.
All right, the state is recommending probation defense.
Yes, Judge.
According to the plea bargain agreement, the state is recommending a length of community community supervision for 4 years. Any objection to that?
No, Judge, there's just what the court needs to be aware of is that my client, when she was arrested in Kentucky, she was in rehab, so she has a drug case in Kentucky in McCracken County that she was put on probation for. She went to rehab for about 10 months, got out, tested dirty, and she was in a rehab facility when she was picked up and then extradited here. And so we would ask that she be allowed, so if she is given a probation, she would be returning back to a place called Recovery Plus, which was her inpatient.
It's an inpatient
Yeah.
rehab,
Inpatient rehab, and I believe that's in McCracken,
no, in Madisonville.
Madisonville, Kentucky. So we respectfully ask that if her probation could be transferred there.
All right, probation, are you aware of excuse me, we're on the record.
I'm sorry,
There's a sign that says don't approach while we're on the record.
I apologize.
All right, thank you. All right, probation. Are you aware of this Recovery Plus that's in McCracken?
I am not, Judge.
All right. Do you know how long the treatment is?
6 months, Judge. And she completed about 30 days when she was arrested. So she's got about 5 more to go.
All right. Probation, do you have any objection to her being transferred to Madisonville, Kentucky? According to the TAP evaluation, they're recommending safety.
Right, Your Honor, we also don't have an accurate address here on this PSI, so we're gonna transfer her to what address? There's no address listed.
And my understanding is that they're willing, the folks at Recovery Plus are willing to come get her.
All right, so the address,
It's on East Center Street.
all right, the address the court has from Google is 336 East Center Street, Madisonville, Kentucky, 42431. All right, so this is what the court is going to do. Court is going to sentence you to 2 years in the state jail facility, suspended for 4 years. There's a $500 fine that will be probated. This will run concurrent with County Court Cause number 685538. Taking consideration 2023 CR 2440, County Court Cause number 685330. There's to be restitution, if any, to Justin Aljet, Charles Steve Birchfield, Lachawazua Wilson. She's to remain in custody until transfer to Recovery Plus for Women, located at 336 East Center Street, Madisonville, Kentucky, 42431. The court will allow request a transfer. What county is that?
I'm not quite sure, ma'am. I'm
All
sorry.
right. I'll look it up. All right, thank you. So there's to be a transfer to Madisonville, Kentucky. Do you have any family in Madisonville?
No, ma'am.
Her significant others are the church people and
Wait, I can't understand. What did you say?
her significant others who she was residing with before were her church friends from Kentucky. Was at Paducah?
Yes.
In Paducah, Kentucky, which is McCracken, Kentucky, which is where her case is being managed from, Judge. So Madison is not, is that close by?
Yeah,
Yeah.
it's where the.
All right, everyone, when we're on the record, don't talk behind the court reporter. You can ask that your client be moved down there. If it's crowded down there, everyone will just have to wait your turn.
Yes, it's where the probation have sent me for rehab.
All
in
right, so
Madisonville.
I'm doing a transfer to Madisonville, Kentucky. If she wants to transfer someplace other than Madisonville, Kentucky, she needs to get permission from the court. Because I can't have her just wandering from place to place.
Yes, ma'am.
And if these charges were picked up by her while she is with the church people, then maybe those are not appropriate people.
No, they weren't picked up when I was living with them, ma'am.
All right, so here's the thing. You're not allowed to transfer from Madisonville, Kentucky, unless I allow you to transfer from there.
Yes,
You
ma'am.
understand?
Yes, ma'am.
And you're gonna have to sign a release from this Recovery Plus for Women so that probation can see how you're doing. You understand?
Yes, ma'am, I will.
All right, do you have any children?
No, ma'am.
All right. There's going to be regular reporting by Zoom or in person. There's going to be regular random UAs. There's going to be 120 sober meetings and 120 days upon release from Recovery Plus. Did you obtain your high school diploma?
No, ma'am.
All right. Oh, State, you may be excused. Thank you. Let me give this to you, counsel.
Sorry, Judge, waiting for my moment.
All right. And let me give this to you. So what are you planning on doing with your life?
Getting my GED and trying to do the right thing.
All right, so I'm gonna set your community service restitution hours at 120 hours. Once you obtain your GED, 60 of those hours will be satisfied. And then if you are in someone's trade school and obtains your certificate, or if you're seeking a higher level of education, the remaining 60 hours will be waived. Do you understand?
Yes, ma'am.
There's going to be proof of employment within 30 days of release from custody. There's to be no employment as a home health care provider or with minors. And if they are able to do field visits in Kentucky, I'm going to want field visits 1 time per month for 6 months upon release. Probation, is there anything else she needs?
No.
Is there anything else you need from the court to be successful?
No, miss, I appreciate everything you've doing.
All right, thank you. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
yes, ma'am.
All right, good luck to you.
Thank you.
Just
yes.
one last thing. So as part of the plea agreement, he was supposed to plea on one misdemeanor, which is a failure to stop and give information. And we did that on May 15th.
Okay.
Okay, already. So that, she's done all that already.
All right, thank you. We can go off the record. Here's the thing. In this court, to be successful on probation, communication is key. If there is an issue, call your probation officer and let them know. Your probation officer is going to be in Kentucky. If you feel as though they're not responsive, you can call the probation office here. You understand?
Yes, ma'am.
And do not leave Madisonville, Kentucky until I give you the okay to leave that place. You understand?
Yes, ma'am. So I'll be waiting for the jail in Madisonville, Kentucky to come get me to.
No, your attorney has told us that
Okay.
Recovery Plus will actually send someone here to pick you up.
Okay, and I'll let them know to get a hold of the jail to release me or to get a hold of who to release me to them.
Probation will probably be able to give you better information than I can.
Okay.
All right. Probation.
Yes, Judge.
The number to Recovery Plus, according to Google, is 502 947 4850.
Got it.
All right, thank you.
Thank you,
All
ma'am.
right, thanks, Judge. Can I be excused?
Yes. Court is calling 2024 CR 5072. Counsel, you're on this side. State of Texas versus David Michael Lind. Could I have parties announced for the record for the state?
Andrew Harris Edmond.
Defense?
James Seeloff for the defense.
All right, and then are you Mr. Lynn?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review that with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Lynn, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we waived the reading of the indictment.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Lynn, did you review the document entitled Court Admonishments and with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of theft under $2,500 enhanced? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand? I'm sorry, just one moment. Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he was.
Mr. Lynn, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 14 months in the state jail facility. The state opposes your application for community supervision and deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That's our plea.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both
Yes,
places?
ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No motions.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Contained in Exhibit 1 and any attachments, Your Honor.
No objection.
All right, state, you may be excused.
Thank you, Your Honor.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did
Yes,
you
ma'am.
understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Counsel, do you wish to proceed with sentencing?
Your Honor, we have applied for deferred and probation. The state opposes.
All right, so, okay.
And it's a cap of 14. If you still want to waive or go to PSI.
No, we'll do the PSI
Yeah.
probation. They're saying the PSI is August 22nd. Is that the earliest we can do?
Unless it's a rush.
All right, can we do a rush? All right, what would be a good date then? All right, Ms. Ferguson, if you can recall this for 4 weeks then. All right, we'll come back on July 25th, and probation, that'll be a PSI and TAP evaluation. All right, Ms. Ferguson will give you a reset form. After he speaks with probation and signs the reset form, he'll be excused.
Thank you, Your Honor.
All right, thank you. Who's here on Sarah Gutierrez? All right, so has it been discovered? Family violence case, not a family violence case?
So update for the court. So since the last setting, Ms. Gutierrez's case in the misdemeanor courts was transferred to County Court 13.
Okay,
But then there is this new accusation that could potentially lead that County Court 13 case to be filed as an indicted repeater VPO. I discussed with Mr. Dunn. He has no update from intake at this point. He gave me the contact information for the intake attorney for the court that I would need to contact about a timeline about when that could be indicted. I discussed with Mr. Escobar, and he is actively providing me reports for those accusations, so we are getting updated on that as well. And I discussed with Ms. Gutierrez, she is interested in accepting the state's offer to TIC this active case with a plea of a combination of those cases. The holdup for the court, of course, is getting those cases filed so that we can enter the case, confirm 3914 is being complied with, and then have it.
all right, so I'm giving you all a plea deadline date. There will be no further extensions of plea deadline dates. This case has been on the docket for a while.
Understood.
I understand that there were a lot of moving parts. So I'm setting this at the end of July, and that's plea deadline date.
Yes.
And make sure you're on time, okay?
Yes, Your Honor. Thank you so much.
You're welcome. All right, Ms. Ferguson, what date? All right, we're gonna come back on July 30th, and thank you for dressing appropriately for court.
Thank you, ma'am.
You're welcome.
Thank you, Judge.
All right, once you sign the reset form, you're excused.
Ma'am.
So in this case, there was an issue of whether or not he's a citizen. The defendant believes he's a citizen, but you all were to check into that.
I will ask Monica about that.
All right, and this is a family violence case. Are you aware? Okay. Zach Dunn,
Yes, Judge.
this is a family violence case.
Which case is this, Judge?
Ramiro Sandoval.
Okay.
CPS record?
Yep.
All right. So there was an issue. He thinks he's a citizen. Nobody knows if he's actually a citizen. That's supposed to be checked into. So where are we on discovery?
Well, while they're gonna check into that, then, do you mind as well, Your Honor, if we get your signature here? This is a case where we have the records. And it's going to come by to view the forensic interview. When they do that, it'll be a 2-for-1. We'll give them our copy that the paralegals create and they can do the forensic.
All right. Ms. Ferguson, this is going to be recalled for the end of July for discovery. You all need to be prepared to sign a discovery acknowledgement, and the immigration issue needs to be solved. All right, we'll be back on July 29th for discovery.
Thank you, Judge.
You're welcome. Is there anything else?
Nothing further, Your Honor. Thank you.
All right, Ms. Ferguson, if you'll give him a reset form. And also, Norma, if you can make sure Charles Bunk, last client, gets a reset form as well. All right, thank you so much. Have a great day.